If you are married to a U.S. citizen or planning to sponsor your spouse for a green card, everything just changed on January 1st, 2026. The U.S. Citizenship and Immigration Services has implemented the most comprehensive overhaul of marriage-based immigration rules in decades, fundamentally transforming a process that millions of couples rely on to build their lives together in the United States. And what used to be a relatively straightforward process with predictable timelines and reasonable expectations has now become significantly more complex, substantially more expensive, and far more scrutinized than ever before in the history of the American immigration system. The changes we are about to discuss affect every stage of the marriage-based immigration process, from the initial application through the final approval of permanent residence and even beyond to the removal of condition stage for couples who received conditional green cards. Whether you filed your application years ago and are still waiting, whether you just got married and are preparing to start the process, or whether you are somewhere in between, these new rules will impact your case in ways that demand immediate attention and careful preparation. Welcome to U.S. Immigration Info, your trusted source for accurate, comprehensive, and timely immigration information that helps you navigate the complex and constantly changing landscape of U.S. immigration law. Today, I am bringing you urgent information about the new marriage green card rules that took effect in January 2026 and what they mean for couples across the country and around the world who are trying to navigate this system. Whether you are a U.S. citizen trying to bring your foreign spouse to America to build a life together, a permanent resident sponsoring your husband or wife through the family preference system, or you are already in the adjustment of status process, waiting for your interview or your approval, these changes affect you directly and immediately in ways that you need to understand. If you find this video helpful, please hit the subscribe button, turn on notifications, and give it a like so you never miss important updates delivered straight to your smartphone. Now, let us get into the video. Let me start with the most significant change that has couples across the country in complete shock and scrambling to understand what it means for their cases. USCIS has implemented mandatory in-person interviews for 100% of marriage-based green card applications, eliminating the discretion that officers previously had to waive interviews in straightforward cases. Let me repeat that, because this is absolutely huge and represents a fundamental shift in how these cases are processed. Every single marriage green card case, without any exception whatsoever, now requires both spouses to appear together for an in-person interview at a USCIS field office before any green card can be approved. Under the previous system that had been in place for many years, USCIS regularly waived interviews for many cases that appeared straightforward based on the documentary evidence submitted with the application. If you submitted extensive documentation demonstrating a genuine marriage, if you had been married for many years with a well-documented history together, if you had children together which provided strong evidence of a legitimate marital relationship, USCIS would often approve your case without requiring an interview because the evidence spoke for itself. The agency used its discretion to focus interview resources on cases that raised questions or red flags, while allowing clearly legitimate cases to proceed without the delay and burden of an in-person appearance. Those days are completely over. As of January 2026, the new policy eliminates all officer discretion regarding interview waivers for marriage-based cases. Now, every single couple must attend an interview regardless of how much evidence they submit demonstrating their genuine marriage, regardless of how long they have been married, regardless of whether they have children together, and regardless of how straightforward their case appears on paper. This applies to initial green card applications filed by spouses of U.S. citizens and permanent residents, removal of conditions cases filed by couples who received 2-year conditional green cards, and even some renewal and replacement situations that previously would have been handled administratively. USCIS has publicly stated that this dramatic change in policy is designed to combat marriage fraud, which agency officials claim has increased dramatically in recent years. and requires more intensive verification of every marital relationship before permanent residence is granted. The agency argues that in-person interviews are the most effective tool for detecting fraudulent marriages, and that waiving interviews, even in apparently straightforward cases, created opportunities for fraud to go undetected. Critics of the policy argue that it punishes legitimate couples for the actions of a small minority of fraudulent applicants, and that the resources being devoted to interviewing obviously genuine marriages could be better used elsewhere. Here is what this mandatory interview requirement means practically for couples going through the marriage green card process in 2026. Interview wait times, which were already frustratingly long in many cities across the country, have now exploded to unprecedented levels as USCIS field offices struggle to accommodate the massive increase in required interviews. Field offices that were already operating at or near capacity are now completely overwhelmed, trying to schedule interviews for every single marriage case that comes through the system. There are simply not enough officers, not enough interview rooms, and not enough hours in the day to process the volume of interviews that the new policy requires. Couples who filed applications in late 2025, expecting to be processed under the previous rules, are now receiving interview notices scheduled for late 2026 or even early 2027. We are talking about 12 to 18-month wait times or even longer just to get an interview appointment in major metropolitan areas like New York, Los Angeles, Miami, Chicago, and other cities with large immigrant populations. Some field offices are reporting wait times approaching 2 years from application filing to interview scheduling, which means couples are spending years in uncertainty waiting for the opportunity to prove the legitimacy of their marriages. During this extended waiting period, many foreign spouses are stuck in an incredibly difficult limbo that affects every aspect of their lives. If they are in the United States on a non-immigrant visa that is approaching its expiration date, they face the prospect of losing their lawful status and their ability to remain in the country legally. If their work authorization expires before their interview is scheduled, they lose the ability to work legally and contribute financially to their households. Some couples are forced to live on a single income for extended periods while waiting for work authorization to be restored, creating severe financial hardship. If the foreign spouse is abroad, waiting for their immigrant visa through consular processing, they remain physically separated from their U.S. citizen spouse for a year or more while their case works its way through the system. Couples who expected to be reunited within months are now facing separations measured in years. The emotional and psychological toll of extended separation is enormous, particularly for couples with children who are growing up without one parent present. The financial strain of maintaining two households in different countries, paying for international travel to visit each other, and managing the costs of the immigration process itself has pushed many families to the breaking point. The second major change that couples need to understand involves the interview process itself, which has become significantly more intensive, more detailed, and more personally invasive than at any time in the past. USCIS has issued comprehensive new guidance to officers conducting marriage interviews, instructing them to ask much more detailed and personal questions than they were required to ask under the previous protocols. The goal, according to the agency, is to detect fraudulent marriages by testing whether couples have the kind of intimate knowledge of each other that genuine spouses would naturally possess. Officers conducting marriage interviews are now required to ask about intimate details of the relationship that many couples find uncomfortable, embarrassing, or inappropriate to discuss with a government official in a formal interview setting. Questions about sleeping arrangements have become standard, including which side of the bed each spouse sleeps on, what time they typically go to bed and wake up, and what their bedtime routines involve. Questions about bedroom furniture, bathroom arrangements, closet organization, and other domestic details are used to test whether both spouses give consistent answers about their shared living space. Financial questions have become far more detailed, with officers asking about specific account balances, monthly expenses, who pays which bills, how financial decisions are made, and other matters that require couples to know precise details about their shared finances. Questions about daily routines probe everything from who makes breakfast to who takes out the trash to what television shows they watch together. Officers are instructed to ask about family planning, including whether the couple plans to have children, what birth control methods they use, and how they have discussed their reproductive future together. Questions about physical intimacy, while not universally asked, are now part of the approved question bank that officers may draw from if they believe such questions are necessary to assess the legitimacy of the marriage. The interviews themselves have become much longer than in the past, reflecting the more intensive questioning protocols. What used to take 20 to 30 minutes for a straightforward case now regularly extends to 60 or 90 minutes, or even longer, depending on how the officer chooses to conduct the interview and whether any inconsistencies arise that require follow-up questioning. Couples should prepare to spend several hours at the USCIS office on their interview day, including time for checking in, waiting, the interview itself, and any additional processing that may be required. Perhaps most significantly, officers are now routinely separating spouses and interviewing them individually in different rooms to compare their answers and look for inconsistencies that might suggest the marriage is not genuine. This separation technique, sometimes called a Stokes interview after a famous fraud case, was previously reserved for cases where officers had specific reasons to suspect fraud. Now it is becoming standard practice even in cases that appear straightforward. Even minor differences in how spouses answer the same questions are being flagged as potential fraud indicators worthy of additional investigation, creating anxiety for legitimate couples who simply remember details differently or who have different perspectives on aspects of their shared life. The third major change that is catching couples completely off guard and raising serious legal and privacy concerns involves the implementation of surprise home visits as part of the marriage verification process. USCIS has implemented a new policy giving immigration officers authority to conduct unannounced visits to couples' homes to verify that they are actually living together and maintaining a genuine marital relationship as they claimed in their applications. This represents a dramatic expansion of USCIS investigative authority that many immigration attorneys and civil liberties advocates have criticized as overreaching and potentially unconstitutional. These home visits can happen at any time without advance notice to the couple. Officers may arrive early in the morning, in the evening after normal business hours, or on weekends when they expect both spouses to be home. They arrive without warning or appointment, knock on the door, identify themselves as USCIS officers, and expect to be allowed into the home to conduct their inspection. The element of surprise is intentional, as the agency believes that giving couples advance notice would allow fraudulent marriages to stage their homes to appear genuine. Once inside, officers conduct inspections, looking for evidence that both spouses actually reside at the address and share their lives together as a genuine married couple would. They are checking for 2 sets of clothing in closets, looking at whose belongings are in which rooms, examining photographs together displayed in the home, reviewing mail addressed to both spouses at the address, and looking for other indicators of shared living such as toiletries for both genders and bathrooms, food preferences of both spouses in the kitchen, and personal items belonging to each spouse distributed throughout the home. Officers take notes and photographs documenting what they observe, and their findings become part of the permanent record in the couple's immigration file. Any inconsistencies between what the couple claimed in their application and what officers observed during the home visit can be used as evidence to deny the application or to refer the case for fraud investigation. Couples who cannot or will not allow officers into their homes face serious consequences. Refusing entry or being unable to accommodate a visit because the couple is not home at that moment can have their applications denied for failure to cooperate with the investigation. This has created impossible situations for couples where both spouses work demanding jobs, travel frequently for employment, or simply were not home when officers happened to arrive. The policy has also created serious privacy concerns and raised legal questions about the limits of USCIS authority to demand entry into private homes without warrants based solely on the filing of an immigration application. Many immigration attorneys are advising clients about their constitutional rights in these situations. But as of January 2026, the surprise home visit policy is official, and couples must factor it into their planning. Those who refuse entry should understand that doing so may result in adverse consequences for their immigration case, while those who allow entry should understand what officers will be looking for and ensure their homes reflect their genuine shared life together. The fourth major change affecting marriage-based immigration is the dramatic increase in required documentation that couples must submit with their initial application to meet the new evidentiary standards. USCIS has substantially expanded the list of evidence that couples must provide to demonstrate the legitimacy of their marriages, and applications that do not meet these heightened documentation requirements face denial rather than the requests for additional evidence that were common under the old system. The old standard for marriage-based applications was to provide a reasonable amount of evidence demonstrating the genuine nature of the marriage. This typically included some photographs of the couple together at various points in their relationship, some joint financial documents such as bank statements, tax returns, or insurance policies, and affidavits from friends and family members who knew the couple and could attest to the legitimacy of their relationship. This level of documentation was generally sufficient for straightforward cases where there were no obvious red flags. That standard is no longer sufficient as of January 2026. USCIS now requires couples to submit a minimum of 20 different types of documentary evidence spanning the entire relationship from first meeting through the present day. The agency has published detailed guidance specifying the categories of evidence required and making clear that applications lacking comprehensive documentation will face serious consequences. The required evidence now includes detailed timeline narratives explaining how the couple met, when they began dating, major milestones in their relationship, when they decided to get married, details of the wedding and honeymoon, and how their relationship has developed since marriage. Couples must provide communication records from the early dating period, demonstrating ongoing contact and the development of romantic feelings, which may include text message logs, email correspondence, social media messages, and records of video calls or phone calls. Evidence of relationship milestones, such as meeting each other's families, taking trips together, celebrating holidays and birthdays, and other significant events must be documented with photographs, receipts, and other corroborating evidence. Extensive financial documentation is required, including multiple years of joint tax returns, bank statements from all joint accounts, evidence of joint credit cards or loans, documentation of joint ownership of property or vehicles, and records showing financial interdependence. Insurance policies naming each other as beneficiaries, retirement account beneficiary designations, life insurance policies, and health insurance coverage showing both spouses must all be submitted. Property documents, lease agreements showing both names, utility bills addressed to both spouses, and other evidence of shared residence round out the extensive documentation requirements. The agency has specifically stated that applications submitted without comprehensive documentation will be denied without the opportunity to submit additional evidence. In the past, when USCIS received an application that was missing certain evidence or that raised questions, officers would typically issue a request for evidence, giving the applicant an opportunity to provide additional documentation before a decision was made. This practice gave couples a second chance to strengthen weak applications and was seen as a fair way to handle cases where applicants did not understand the evidentiary requirements. Now, USCIS is taking a much harder line and denying cases outright if the initial application package does not meet their heightened documentation standards. Couples whose applications are denied must start over from the beginning, paying new filing fees, gathering new documentation, and joining the back of the processing queue. This policy change has made the initial application critically important and has eliminated the margin for error that previously existed in the system. The fifth major change causing enormous problems for couples across the country is the new income requirement for U.S. citizen and permanent resident sponsors. The poverty guideline threshold that sponsors must meet to demonstrate their ability to financially support their immigrant spouse has been increased by 25% effective January 2026, pricing many sponsors out of eligibility and creating barriers to family reunification. Under the previous rules that had been in place for many years, sponsors were required to demonstrate income at 125% of the federal poverty guideline for their household size. This threshold was designed to ensure that immigrant spouses would not become public charges requiring government assistance, while remaining achievable for working and middle-class sponsors. For a household of two, which is the relevant size for a married couple without children, this meant the sponsor needed to show annual income of approximately $24,000 under the old rules. The new rules require sponsors to demonstrate income at 150% of the federal poverty guideline rather than the previous 125% threshold. For a family of two, this means the U.S. citizen sponsor must now show annual income of approximately $30,000, an increase of $6,000 over the previous requirement. For larger families with children or other dependents, the required income increases proportionally, and the gap between the old and new requirements grows even wider. This 25% increase in the income threshold has immediate and devastating consequences for many sponsors who would have qualified under the old rules but no longer meet the heightened requirements. Young couples just starting their careers, sponsors working in lower-wage industries, sponsors in geographic areas with lower costs of living and correspondingly lower wages, and sponsors who experienced income disruptions are all affected. Many couples who had planned their immigration applications around the old income requirements have suddenly found themselves ineligible without a way to quickly increase their income to meet the new threshold. USCIS is also scrutinizing income documentation much more carefully than in the past, rejecting evidence that would previously have been accepted and demanding additional proof of sustainable income. The agency is requiring multiple years of tax returns rather than just the most recent year, employment verification letters with specific language and details, recent pay stubs covering extended periods, and bank statements demonstrating consistent income deposits. Self-employed sponsors face even higher scrutiny and must provide extensive business records, including profit and loss statements, business tax returns, evidence of client contracts, and other documentation proving that their self-employment income is stable and sustainable rather than temporary or sporadic. If the primary sponsor does not meet the income requirement under the new threshold, they must find a joint sponsor who does and who is willing to take on the legal obligation of supporting the immigrant spouse. A joint sponsor must be a U.S. citizen or permanent resident who meets the income requirements and who signs the affidavit of support taking on the same financial obligations as the primary sponsor. But finding a joint sponsor who is willing to take on a 10-year financial obligation that is legally enforceable and who also meets the heightened income requirements has become extremely difficult in the current environment. Many potential joint sponsors who would have qualified under the old rules no longer meet the new income threshold, and those who do qualify are increasingly reluctant to take on such a significant legal obligation. The sixth major change affects couples where the foreign spouse entered the United States without inspection, meaning they crossed the border without going through an official port of entry, or who overstayed a visa after lawful entry. Previously, if married to a U.S. citizen, many of these individuals could adjust their status to permanent resident without leaving the country through a process that had been available for decades. This option allowed families to remain together during the immigration process and avoided triggering the unlawful presence bars that can prevent people from returning to the United States for years. As of January 2026, USCIS has severely restricted this option in ways that are tearing families apart. Now, even spouses of U.S. citizens who entered without inspection or who have significant visa overstays may be required to leave the United States and process their immigrant visas abroad through consular processing at a U.S. embassy or consulate in their home country. This is a dramatic change from the previous policy that allowed most spouses of U.S. citizens to adjust status domestically regardless of how they entered the country. Fourth, understand that the process will take much longer and cost significantly more than marriage-based immigration has in the past. Budget for 18 to 24 months or longer from application filing to green card approval, and prepare financially for the extended timeline. Expect to spend substantially more on filing fees, which have also increased, as well as attorney fees if you work with counsel, document gathering and translation costs, and supporting documentation such as medical examinations. Financial planning for the immigration process has become essential. We are bringing you these critical updates on the marriage green card rules that took effect January 2026 because we believe that accurate information is the most powerful tool available to couples navigating this system. These changes represent the most restrictive marriage immigration policies in modern American history, and couples must be prepared for intensive scrutiny of their relationships, lengthy delays measured in years rather than months, and significant challenges at every stage of the process. At the same time, it is important to maintain perspective. Thousands of couples successfully navigate the marriage-based immigration process every year, and genuine marriages with proper documentation and preparation continue to be approved even under the new rules. The couples who succeed are those who understand the requirements, prepare thoroughly, and approach the process with patience and diligence. While the path has become harder, it remains open to those who are willing to do what it takes to demonstrate their genuine marital relationships. We will continue monitoring how these new rules affect real families and what legal challenges may arise to various aspects of the new policies. Stay informed, stay prepared, and do not let fear prevent you from pursuing family reunification through proper legal channels. The process is more difficult than ever, but genuine couples who approach it correctly can still achieve their goals of building their lives together in the United States. That is all we have for this bulletin. U.S. Immigration Info Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas. If you have not already, please subscribe to U.S. Immigration Info Channel. Thank you for watching, and we will see you in the next video.